everyone and welcome back to our channel LEXCLIQ. Here I am KANUPRIYA Bhargava and I am currently working as a legal intern with LEXIS and Company for the month of July. And today's our topic of presentation will be around judicial precedents in India. So let us begin with our topic of today. Every developed legal system possesses a judicial organ which adjudicates the rights and the obligations of the citizens of the nation. At the earlier stage, the courts were guided by customs and their own sense of justice. With the advent of society, the legislation became the main source of law and judges decided the cases according to. Even at this stage, the judges perform some of the creative functions. The judges to some extent depend on their sense of right and wrongdoing in matters of the interpretation in filling up any lacunae in the law made by the legislation. In simple terms, a judicial precedent is a judgment or a court of law in India. Precedent is a judgment of a court of law in India which is cited as an authority to decide a similar sense of facts and which can be used by the court as a source for future decision making. According to the grade, precedent covers everything said or done which furnishes a rule for subsequent practices. According to Selmont, in a which may be cited as and followed by the courts. In general judicial sense, it means the guidance or sense of authority or past decisions for future cases. Only such case decisions laid down some rare and new rule or principle are called judicial precedents. Let us now move forward and understand historical aspects of the judicial precedents in India. In ancient society, there was a less disputes and there were very few occasions to go to courts. Local courts like Shashan, Kula, Shreni, Puga were existing at that time. They decided the cases were existed at that time falling in their jurisdiction. There was a little possibility of development of doctrine of precedent due to lack of adequate sources to keep the record. And in the absence of a well-organized judicial system, no doctrine of precedent developed in India as it developed in England. In British rule, the present theory of precedent is stated developing. The Government of India Act 1935 explicitly mentioned that the decision of the federal courts and the Privy Council will be binding on all the other courts.